I am not saying that is what I'm going to do. What I am saying is that if I'm Chief Justice and in Nairobi, the issue of the aid would evaporate entirely. It would only arise if we are moving out of my station to Nanyuki to check on one or two small things, Kisumu, name it, etc., because she would accompany me and be entitled to that which goes with that. But the aid, the employment status, nothing, because she has nothing to lose.
Okay. And lastly, my Lord, this is a small matter. I've also seen another issue which you have been constantly raising is the issue of the security. And from what I saw, you wanted the judiciary to provide security for your Ongata Rongai home from, again, in Nyeri where you are working, maybe in Chuka where you also reside sometimes. So do you want the judiciary also to provide security for your 3 places of abode? If we, as you are writing also, this is one of the documents I saw, you have been writing about that to the CRJ. I
am not sure of that one, yes. But I remember I wrote on security sometimes around 2016, 2017. What had happened is that when we left for Kericho, we left our boy in the house. At the period of seeking security, the young man decided to go solo. He decided to go to hire a place for himself. So we sought security here, and we were even requested to do quarters for these people, and we did. I cannot remember the precise year. It must have been either 2017 or 2016, most likely 2017. But no security came to assist us at Ongata Rongai. So what I did was my public relations with my boy. And 1 year down the line, the place was vacant entirely. For 1 year, nobody guarded it. I thank God for that, for the security which was, divine. So the young man has gotten back. I would not require any security. If you look at my history, I am not very fanciful of issues of security. I can walk anywhere, even as Chief Justice. I have not offended anybody. I have not taken anything from anybody. If you throw a stone to me, you can only be an aggressor. That's my theory of life. I am very, very simple. Simplicity is a hallmark of my life. I have never requested for any security for Chuka. If anybody tells you that, if it is in my writing, let me look at that. I have never requested any security for Nyeri. I have never requested for any security for Kericho. I have never requested for any security for Eldoret. The few months that I lived there, about 2 years, security is not my fancy. Even as Chief Justice, it will not be an issue to me. You might want to force me into it. The government might want to force me into it, but that one we would have to negotiate. I am not insecure whatsoever.
Thank you very much, Judge, and I wish you well.
Thank you, sir.
Honorable Judge, just a small clarification about the card, because you said you just renewed it. There's a new card now. Is that, am I right?
I do not have a new card.
Or is the same one?
I've never had time to go and, I have a renewal of this card.
Okay.
Yes, but I was warned about it by those who are experiencing this game.
Thank you, Honorable Judge. I will now request Commissioner Judge Majaja to take you through some questions also. Judge?
Thank you, Chair. Good morning, my Lord.
Good morning, sir. Good morning, my Lord.
Yes, I'll follow up some of the issues that have been raised by my colleagues who have preceded me. The Honorable, the Deputy Chief Justice quoted to you a quote by Ronald Dawkins, one of the leading jurisprudents. about there being no gaps in the law. I want to just give you a situation, and maybe you'll enlighten us on what you do. A couple, Mary and Peter, let's call them Mary and Peter, are in a relationship. And at some point, the relationship breaks down. Peter, one night, goes into Mary's house and rapes her. Then she conceives. And when she realizes she's pregnant, she goes into a deep depression and decides to have an abortion. At about the same time as Peter is charged with rape, he's leaving the court and he's knocked down by a motor vehicle. And unfortunately, he's paralyzed, neck down. When he hears that Mary wants to have an abortion, he comes before you sitting as a judge to restrain her from having an abortion. Applying constitutional principles under the Bill of Rights, how would you attempt to resolve this issue? Maybe you will tell us briefly.
We have Article 26, the right to life. This one entitles everybody to life. So the attempt by Mary to procure an abortion for the baby or the fetus would be an issue or an obligation, an affront to Article 26, and this would not be a constitutional issue. The right to life is absolute and is an entitlement to every other person. The fetus or the intended baby has that right to life, and therefore should be it should be safeguarded so that we have a natural birth and the baby lives his life. What are the rights of Peter in this matter? Good enough, there was some misunderstanding between Peter and Mary. This is a product of a rape. Does he have any right over that? He does.
And what about the fact that Mary, first of all, she has undergone physical trauma. She has undergone mental trauma as a result of this particular incident. And she says, look, and the doctors have said, if she has this child, she will never be the same. In fact, we will have to take her to Marete. Is that a proper consideration?
It is a proper consideration on medical grounds, on examination or verification by a proper, a qualified medical practitioner. We can the right to abortion is dissipates.
So it is possible that she can have that abortion.
She can have it.
But
if
what about
issues
Peter?
which are threatening her life?
Okay.
And insofar as Peter is concerned, if there's a threat to life, to the life of to the life of Mary, and or a threat to her medical position, which I mean deteriorates this life to.
So if Peter is telling you, look, I'm the firstborn in the family, I'm the only son of my father, I cannot have any other children because I'm paralyzed neck down, and let her have this child. I will take care of the child. My parents are willing. Would that change your position?
It would not change my position because these rights must be looked at consecutively. In the sense that, firstly, from the evidence or the facts of the case that you've given us, the most critical person here is Mary. Mary has suffered psychologically on this matter as a consequence of these events. And if we sustain the pregnancy, she might lose so badly that we may not even be able to recognize her. She has human rights insofar as her life and the enjoyment of it is concerned.
Okay, thank you. Thank you for that answer. I think I'll move on to the next. You have brought us, in your writing samples, you gave us 5 writing samples. One, your dissertation, which I must commend you, under the tutelage of Professor Okoth Ogendo.
Thank God.
Yes. Lucky to have been guided by him. Then you have 4 cases and an article. In your dissertation, which is about, it talks about constitutional dispensation in Kenya, the politics of the constitution and the constitution-making process.
Yes.
And I think what we are going through right now is really, this becomes an important topic right now as we are trying to go through the constitution amendment process. And in your paper, you set out 2 hypotheses. The first one is that Kenya is at a crossroads, and you are talking about that particular time. Is at a crossroads.
2005.
Yes, 2005. And you were saying that Kenya is at a crossroads and suffers a constitutional crisis due to past abuse of the constitutional practice by the ruling elite in the entrenchment of parochial self-interests. And 2, that the current constitutional crisis is a consequence of lack of legitimacy arising out of reluctance of the ruling class to incorporate participation of the people of Kenya with a view to accommodating their views and interests in the new constitutional dispensation.
Yes, sir.
When you become the Chief Justice, one of the things you may have to deal with is amendments to the constitutions that affect the judiciary. If you are writing this dissertation in reference to what the proposed amendments are to this constitution, what would be your conclusion?
If we have to make amendments to the constitution touching on the judiciary, our constitution is very, very clear. The issue of public participation must be had before laws, policies, etc., are had in this country. And it is basically a right that we include everybody in the decision making and in our policies and in the way we run government. So if we would have to have constitutional amendments which touch on the judiciary, then the judiciary must be involved. Kenya in entirety must be involved, because primarily the judiciary is the property of Kenya. If we are not involved, if Kenya is not involved, we are as a most immediate stakeholder with the people of Kenya, then it becomes unconstitutional, and we would put a case against those who are in charge of the process.
What I want you, my lord,
please,
is you have come in and now you have found the amendment in place.
Yes, sir.
You are part of the KMJA, and we have made our position very clear.
Yes, sir.
We think that these amendments are an affront to the independence of the judiciary. In your first address to the judges, to the magistrates, and to the public, given those amendments, what would you tell the public?
I would tell the public that, one, the staff of the judiciary are not happy with the proposed amendments to the Constitution.
No, they've already taken place. You are now Chief Justice. The amendments are here. How are you assuring us, the JSC, the judiciary, the public, that in fact we are independent?
I'll assure my members of staff and the JSC, because I'll be the chair of the JSC, that we shall take immediate steps to renegotiate the amendments which relate to the judiciary. Because if the amendments are there and it is like final, we cannot close that. Conciliation does not end. Would have to, if they are not there, if they are offensive to our functions, we will not close there. We will not say that that is enough. We will not say that we are beaten.
Okay.
We would still push it and raise it.
Okay.
If we get to a deadlock and they are not, it is not done, we leave it at that. We are not going to fist cuff.
Okay, thank you very much for the answer. One of the important areas you will deal with as President of the Supreme Court is the presidential election petition. And I'm sure as you came through this interview process, you familiarized yourself with the jurisprudence, the decisions.
Yes, sir.
And there is a decision that came from the East Africa Court of Justice, Martha Wangari Karua versus Attorney General. You are aware of it?
I have, I know it from the general public, the press.
Have you read it?
I have not read it.
Have you read the cases that led to that decision?
I have not. I relied on the material which was distributed to us some 2-3 years ago, the 2013 elections.
So have you read about the election petitions, the issues about jurisdiction?
Yes, I have, sufficiently.
Sufficiently?
Yes.
So the proposed amendment intends to make the Court of Appeal the final court in respect of election petitions. In your view, is that a good thing or a bad thing?
That is a very, very good thing. I have been through some write-ups by people outside the judiciary and even inside the judiciary. I've read your write-up on that book on elections. I've read Chief Justice Maraga's. I've almost virtually gone through that book. And the issues are arising on the jurisdiction of the Supreme Court insofar as election petitions are concerned.
So what is the issue about right now in terms of the jurisdiction of the Supreme Court in election petition? Where does this jurisdiction come from?
The jurisdiction of the Supreme Court in this matter, in the matter of elections, arises out of Article 163(4), where the issue of interpretation and application of the Constitution comes in, and the alternative issue which.
So what is the? Yes, they said that it's an issue of interpretation and application. But what do the critics say about that approach?
The critics are saying this, and they have raised 4 points. Mothomi Thiankoru, who was involved in the Munya 1 and 2 cases, has written a very beautiful article.
Yes, so what are these points? Just tell us the points.
He says, one, there are amendments to the Constitution, to laws, 2013 amendments, did not touch on the Supreme Court. The amendments which touched on elections in 2013 to the law were for the High Court and the Court of Appeal. That's a first pointer that the Parliament did not have any issues, did not envisage a situation that, would not have wanted a situation that the Supreme Court becomes an arbiter in election petitions. That is the first pointer. The second one is the capacity of the Supreme Court. There are 7 judges. We have 67 senators, 47 governors. We have 390 MPs, 1459 MCAs. Would any sensible Parliament have anticipated that or provided that in the Constitution, so not the Parliament, but the constitutional drafters, would they have anticipated a situation that the Supreme Court is able to deal with any leftovers, because leftovers are the appeals over these matters, and they deal with it?
The third point? The third point?
The third one is decisions of the Supreme Court itself before 2013. The decisions of the Supreme Court pre-election pointed out that this is a memento court, which only comes out at moments of constitutional constitutional interpretation, or they call it a constitutional moment. That is when we rise up and answer to this. So if that be the case, then why would it have to shift immediately after the election, so that every other matter which is in the Court of Appeal, etc., would have to get to the Supreme Court? Okay. And lastly, Mudhomi Thiankolu argues that any looking at the Constitution of Kenya 2010 does not indicate, there's no indication whatsoever that it intended that the Supreme Court becomes a final appellate court in election petitions. If you read the Constitution.
So, if the amendment does not go through, what position would you take?
As the President of the Supreme Court of Kenya, as the Chief Justice of the Republic of Kenya, this is an issue of public controversy. The jurisdiction of the Supreme Court, and particularly relating to election petitions. What would I do? Firstly, call our people, the Supreme Court itself.
Let's put it this way, because you don't discuss, you don't decide cases outside live cases.
Yes.
The court has said we have jurisdiction.
Yes.
What is the reverse point? You would say, if you decide that the court has no jurisdiction, in what instances then would matters of elections come to the court? Because you can say, if the court had not said, elections petitions do not have matters of interpretation and application of the Constitution, in what other way would election petitions reach the Supreme Court?
In my own thinking, supposition, and from what I've read, firstly, I would consult widely, particularly amongst the judges of the Supreme Court, so that we come up with our position on the matter. After coming up with our position on the matter, we would go to other stakeholders, those who bring in these arguments and thrash it out, so that we come up with a concrete position which would act. I am warned that I would not go and bulldoze the judges of the Supreme Court into any position insofar as
it is true you would not bulldoze anyone, but now we are having a discussion. Say, before you come in, the court says an election petition is not a matter of interpretation and application. In what other way would an election petition come to the Supreme Court, other than a application and interpretation of the Constitution?
I would be very, very, very vague at personal level.
No, not at personal level. You are the judge.
I'm the Chief Justice.
Yes.
We have the judges sitting and deciding on what to allow in and what not to allow in.
Yes. Precisely that.
In that kind of a circumstance, we would have to scrutinize the matters for constitutionality, because it has been argued that if you wanted to raise this matter and enlarge it, every other activities of our lives are constitutional matters.
Okay, I will leave that for you to digest.
Thank you.
The next point I want to take you through is what my colleague Commissioner Warsame touched on. He talks about your driver. He raised the issue about your drivers. You have explained it. But there's another concern which there is a case here. First of all, you are the Teachers Service Commission.
Yes, 5 years and 70 days.
5 years and 70 days. And you were relieved of your duties there.
Yes.
And you went to court.
I did.
And the court vindicated your
all the time.
Yes, vindicated your position. So, in one of your judgments, this is the case of Professor Misia Manuguti Kadenyi and Masai Mara.
Yeah, the Masai Mara University
yes.
case.
And it's not anything to do with what you did. It's just I want to put to you a situation which, in that decision, and this is what you said. On this, I wish to rely and take credence on the authority of D.K. Njagi Marete versus Teacher Service Commission, 2013 Ikelar, where my good friend and brother, Rika J, very ably interrogated this term, and you were talking about termination and retirement, and came out as follows, and then he stated the law.
True.
Now, as a judge, wouldn't this kind of statement worry you that this is you're quoting your own case?
One.
Two, you're saying my good friend and brother Rika J, a case which you succeeded. Wouldn't that worry you?
Good enough. It's a question of expression. One, when I quoted the matter because throughout our jurisprudence in the court in the last 8 years, or any other jurisprudence, I have never had occasion to find anybody who had that succinct and a very good definition of what retirement on public interest is.
Okay.
So it's a matter which fascinated me. In fact, I would give him 1,000%, not 90 or 100. 1,000%. It was beautiful and nice. Okay. On the other issue, we were here in 2011 and 2012, and I learned from the JSC then when we came for the interviews for appointment, the issue of language and talking softly, and I can't remember the term they use. Is it a hard language? I can't remember. But whatever it is.
Yes.
One, I am a student of literature, and I believe in expression.
Yes. The point is, before we go on, the point is, if the Teacher Service Commission were reading this judgment,
yes,
okay, you fought them in court.
Correct.
Now you are referring to the judge as my good friend and brother. What is the perception they would have?
One, a good friend. Mm-hmm. There is no possibility. You know, you are my very good friend, a good commissioner. We work together. We are in the same station. We are in the same court, the High Court and the Equal State. We are in the same. We are equals. We interrogate when we find occasion, like in the colloquiums or when we meet in the streets or in the corridors of the course, etc., etc. I have no enemies whatsoever.
No, the point I'm making is not that you have no enemies, you have friends. But you know, for a third party, this is Teacher Service Commission, they have been in litigation with you, then in a judgment, you're quoting, you say, "Judge, my good friend and brother." Don't you think that's an issue which you ought to reflect on?
It could be an issue
yes.
if you are a simpleton. This is the English we are speaking, not the language of the people of Chuka. Even in the language of the people of Chuka, it will be the same. We are saying, I have done some descriptive, a reference to, that's what I feel about him. Okay. It has nothing whatsoever to do with what he gave me. In that judgment, he clearly tells everybody, the whole world, that in that period that he was dealing with the matter, none of us, Judge Onyango, the principal judge, was the prosecutor. He prosecuted that matter for the...
Okay, thank you for that explanation. I'm satisfied. So I'll just go back to the last issue. In your earlier discussion, and you laid a lot of emphasis on that, you talked about, you really emphasized your relationship with staff, making staff happy, motivated, and being friendly. In this case of Collins Odumba, it was a case for contempt, isn't it?
Yes.
And the accused there was a member of staff.
No doubt.
Was a member of staff.
Yes.
Now, one of the complaints I have had, and this has been mentioned to me, is that the staff accuse you of being high-handed and heavy-handed. High-handed and heavy-handed. So this was a case where, and if I may just read for you, you say, on the morning of 27th, we were treated to a now commonplace spectacle during proceedings in court. In the middle of the first phase, there were loud, continuous noises heard from outside the courtroom. It was clear that this was a chat between two persons, and the volume and continuity of that noise forced the court to stop its proceedings, as this was not possible or practical. So there was noise in the court, isn't it?
Yes, on the corridors.
On the corridors, and you were unable to proceed.
Correct.
You then went and inquired, who is this making noise? Sent your clerk, find this person.
Bring him in.
Bring him in. Okay. A lot of things happened between, and he was finally charged with contempt. In fact, you said on 30th, this was on 27th, you realized the accused on 30th, this is from your own writing, on 30th May 2016, the accused, who I now realized was a court staff or officer, was brought to court at around 11 hours. 100. What I want to ask you is this. We know contempt is a very serious issue.
No doubt.
Yes, and in fact, you recognize that in your decision.
Yes.
But this is a member of staff.
Yes.
Is a member of staff.
Yes.
Surely, weren't there mechanisms within that station you could use to deal with this particular issue?
If you read the ruling, clearly, you'll appreciate that this was not a one-day matter. This matter had continued for well over 6 months. We addressed issues of people making noise in the corridors, day in, day out, etc., etc., etc. And we had even the chief magistrate, now Judge Ongondo, had taken steps, plus my dear Mr. Ndoruri, had taken steps to fight this menace, but it would not go away. For a long, long time, we have this issue, and it is not going away. For a long, long time, we have, the cells down there, and there's noise, and it is refusing to go away. We cannot sustain this.
Mm-hmm.
So on this day, we have the noise. People are chatting in the corridors, and the court is continuing, and we call for the officer. we call for the persons who are making the noise. One is brought in. In fact, there were 2 members of staff. One is brought in. The other one says nothing. I am not heeding to that call. What choices did we have? What I did was stop the court and defer proceedings and deal with the matter. How did I deal with it? I got the person arrested and brought it to court. When he was brought to court, he was so panicky, etc., and I said, put him in. We have no time. We can deal with him on a different date, on a Monday. We resumed the court.
Okay.
That is the circumstances under which we dealt with that matter.
Okay.
The nuisance had been continuous for a long time, and we suspected that it could even have been deliberate and political. Okay. Otherwise, how are we able to deal with noise day in, day out, 1 week, 2 weeks, 3 weeks, etc.?
In fact,
those are the circumstances in which we found ourselves, and we had to be firm. High-handedness and firmness are 2 different things. I have never boxed any of my officers. In fact, my officers are very, very happy with me. Where you get this kind of reports, good commissioner, I would not know. But when you get that kind of report in the future, even when I am Chief Justice, get that person.
So at the end of the day, would you now you're the Chief Justice tomorrow? Maybe you're the Chief Justice tomorrow. Are you telling staff that in fact the criminal law will be brought to bear to them for any infraction? That they should fear you because you're the Chief Justice who resorts to the criminal law in order to resolve problems in administration? Is that something you want to tell them, to reassure them?
That is not the message. This was an exceptional case and a last resort. If we had not taken that kind of step, administration had been there. We have a DR, we have a chief magistrate,
in fact,
we have a presiding judge, and this issue had been, they had handled these matters, and they were not coming there was no solution. Particularly when the officer one officer comes to court and sits there with us so that we interrogate the issue of noise.
Okay,
the other
Judge.
one doesn't, that refuses flatly.
Yes.
How would you deal with that?
In fact, in your judgment, you say this issue has variously this is your own words, reported to the judicial officer in charge of the station, but to no avail. So you had reported to the station.
Yes.
And you even asked, who is in charge here? The Chief Administrative Officer, Rate CEO of Kericho Law Courts, is the Senior Principal Magistrate, one, George Ongondo, that is now our colleague in the Superior Court. What tale of expedient court administration does this portray? What are our levels of leadership in this sector? One thing I want to ask you, were you a member of the LMT in Kericho?
I was.
You were. Was this issue raised?
It died with the prosecution or the litigation of that matter.
No, prior to the prosecution, was it raised?
It never featured as a matter for discussion in the LMT.
Yes, it never. So you were aggrieved many times that this is an issue of noise. You attended the LMT, never raised it. Thought it was serious enough. Started contempt proceedings before yourself. And then in your own judgment, you indict the leadership of Kericho. So what I'm just asking, should the staff, judicial officers, heads of station have faith in you as the leader to lead this judiciary?
My answer is loud and very, very clear. Everybody is entitled to their feelings on any matter. We cannot take away that right. It is indivisible and a human right. The staff of the judiciary would have to have their own assessment, have their own feelings about me, etc., etc., etc. I have my position, and I will assure you, Commissioner and my Lord, that we cannot lead without firmness. You will not get anywhere. You will not get any results. You have to be firm in what you do so as to be able to establish, to get results, to establish your policy, to establish your work ethics, your standards.
Okay, thank you very much, my Lord, and wish you well.
Thank you.
Okay, thank you very much, Honorable Judge. We will have a short break. But before we do that, Honorable Judge, we must observe the constitutional requirement regarding diversity, so which is your county? Is it Meru?
No, I'm not from Meru. I never was from Meru. In that great Meru, we were just sojourners.
Okay.
And peripheral.
All right.
I come from Tharaka Nithi.
Tharaka Nithi?
Yes.
Thank you. And ethnicity, Judge?
I am Chuka.
Chuka.
Yes.
Thank you very much. And then there's a request, Your Honor, that the card that you have, we would like to see it, just to compare it with the card with Judge Wasame, so the CRJ will pick it from you, Your Honor. And we will have 10 minutes break. We come back at 11:20.
Thank you, good chair.
Thank you. So, Commissioners, we can take a break for 10 minutes. Thank you.
How do we do it?
In journalism training, only 5 viewpoints matter for a proper story. My experience as a business journalist has, however, taught me that there is more. So now I understand that before I walk into that interview, I have to look for the hidden. So for me, what sticks is the story behind the story. What would you say is that unique, very unique selling aspect that you can guarantee I will not find anywhere else?
Good question.
My name is Ingrid Nantege, and this is Metro.